Now I give the floor to Gabriel, who is going to present to you our speakers.
Okay, so on behalf of the CEIPI, we would like to thank our panelists for being here with us today and sharing their expertise. Today, they will give us a brief general overview of the Russian IP system and talk to us about the recent legislative developments, particularly those in the pharmaceutical field, which, as you can imagine, are a very, very pertinent subject in the current global context. First and foremost, I would like to apologize if I mispronounce our panelists' names. Our friend Anastasia tried to explain to me the correct pronunciation several times, but as it turns out, Russian is very, very hard. So our first panelist, Dr. Natalia Kapyrina, is an associate professor of the Moscow State Institute for International Relations. She has a wide range of knowledge on the field of IP law, but she holds a particular interest in the models and designs field. We are also happy to host Alexandra Bakhtiozina, who is currently an associate of Global Regulatory and Intellectual Property, Media and Technology Practices Group at the international firm Hogan-Lovells. Thank you both for being here.
Thank you.
Okay.
Thank you very much. Thank you, Gabriel. Thank you, Anaïs and Elodie, and thank you everyone for letting us participating. Just a little, yeah, that's what I was waiting for, that Thierry Debled could join us. Well, it's always a pleasure to come back to Strasbourg, although it's not completely coming back to Strasbourg, and to travel to France, even on online mode. We will indeed be, we're very happy to share some of the knowledge and practice on Russian IP law today. As you see behind Thierry, you have a nice representation of the Red Square. And actually, just behind him, you would find that cathedral that was on the post that students were have used to announce the presentation. So, well, Thierry is with us as well tonight in Moscow. How do we?
Can we start? Yeah, and can you hear us?
Of course.
Okay, so
yeah. So now I will put the slides on. Wait a second. I'll manage. Maybe. I hope so. So now you see the slides. Perfect.
okay.
Thank you very much. So once again, well, IP in Russia today, it will be really a general overview of the recent developments and some aspects that you maybe don't know for the moment, but things that will give you an introduction to what IP looks like in Russia. The things that we'll discuss today will be, first, we'll give you a little bit of the context with some historical insights, elements of the current system as well. Then Alexandra will present to you IP, well, patents in the pharmaceutical sector to what's happening today. And then we'll do a roundup of the IP year with major developments in legislation and a little bit also in case law. In patents, GIs, generally distinctive signs, with some aspects of well-known trademarks as well, a little bit of copyright enforcement, and to close all this with evidence and enforcement, administrative enforcement as well. So it looks like a very long list.
I'm sorry, we don't hear you anymore. I think you blocked the sound.
Sorry, I blocked the sound, indeed. Yes, so I was saying that it seems a lot. We'll have a lot to present tonight, but in the end, we'll try to make it as simple as possible, and we'll be very happy to get your questions as well at the end, after all the presentation ends up, and after that by mail also if you have any questions. So first, the context. Well, here you see a map of late 18th century, I think, of the Russian Empire, but yeah, whatever. So generally speaking, IP in Russia started in the 19th century, and it developed in the 19th century. First provisions on copyright appeared as a part of the Censorship Act in 1828. The Censorship Act was the one that was dealing with book printing and bookmaking. Everything was, well, state organized. But after that, we see in the 19th century some developments of the copyright laws that entered new objects, new subject matter, and well, offered some rights. The most important copyright law of the pre-revolutionary era was in 1911, but as you can imagine, it didn't survive much longer than, well, it was still working after the revolution until 1925, more or less, but unfortunately, apparently it was a very interesting and modern copyright law. As for patents, there was a manifesto on privileges for inventions that was introduced in 1812, and then a first modern patent law in 1830, which established the main principles, the main notions into Russian law. Then, as for trademarks, although trade signs were something that was mandatory already in the 18th century. In the 19th century, first find a first act that made it all mandatory, that introduced criminal liability for infringing someone else's, well, it wasn't trademark at that time, it was like marque de fabrique or things like this. And then modern trademarks were introduced at the end of the 19th century with the evolution of the market, well, industrialization and market economy in Russia. As for industrial designs, there's also quite an old registration system. There was one at the end of the 19th century. So then in the middle of the 20th century, it almost disappeared. But as you see, well, in general, the history is quite long, although, well, it still needs to be studied so much more. In the Soviet period, during the times of the USSR, intellectual property was protected. There was not something that, it's not something that didn't exist. But we have to bear in mind that IP as an instrument that was, well, which is a free market oriented instrument, it had to be adapted to a non-market economy, to state planification, and to some of the well, ideas that prevailed at this period. For instance, some of the works of authors and musicians were nationalized, but against a remuneration, a fixed remuneration rate that was happening in the 20s. Also, something we have to bear in mind is that the years after the revolution and the years just before the fall of the USSR are great times of change and transition, and there are many interesting writings of this period and many legislative proposals also at the end of the 80s with Soviet laws of 1991 that were really interesting, but well, they often entered into force already after the fall of the USSR. As for patents, something that should be said, there were patents mainly used by foreign applicants, but also there were author certificates. Those were titles that were given to inventors in the USSR. And we have to say that scientific progress and inventorship was very much endorsed by the whole culture and the state. Those certificates were, well, giving remuneration to the authors, who of course could go to the authors of the invention, to the inventors, but they of course couldn't exploit, they couldn't exercise their rights because, well, they couldn't create their own industries, and they couldn't license their inventions neither. As for copyright, one thing that I wanted to say also is that during the 19th century, Russia did not participate in the beginnings of the Berne Convention, and you have letters from Zola and other authors of the 19th century where it is expressed that that Russia has to join also all the international efforts to protect foreign works, well, which actually happened only in 1973 when the USSR joined the Universal Copyright Convention. Before that, in the 19th century, there were some bilateral treaties that organized the protection of foreign authors in Russia and then in the empire. But there was there was a right that was quite important in the Soviet Union and in Russia before. It was the translation freedom, and that was one element that was specific to the system. Although one thing I have to say that, well, there was no registration for works. This was the principle that was from the beginning in Russian copyright, and the right was arised from the creation itself, something that you know from the French and EU laws. So today, Soviet IP history is part of the books, and sometimes some questions are raised as to applicable law, well, regarding some of the some industries. You were saying the cartoons industry, for instance. Also, another issue that you might be familiar with is the question of who owns a trademark which was formerly a trademark or a sign that was used in the Soviet Union. But those are things more or less of the past. So today, the current state of play is that IP is protected as well. Generally, IP rights are all described in the 4th part of the Civil Code, so it is in the same book as the other civil law procedures. It is an autonomous part inside the Civil Code, plus offenses, criminal offenses are within the Criminal Code, and administrative offenses are within the Code of Administrative Offenses. And you find other provisions as well in other legislations. For instance, in the law on information, you have some elements, but most of the IP is in Part 4 of the Civil Code. So when you will see on the slide CCRF, it's Civil Code of the Russian Federation. That's the name of it. After 1991, there were several laws adopted, and there were also several major reforms in the 90s, but then also in the process of accession to the WTO, Russian legislation had to be readapted to the TRIPS agreement. And then there was another major reform in 2014, and the spirit of reform, legislative reform, is in the air, and it's very much spoken of by the profession. About, well, generally in the current trend, something that we can feel in the air is there is a work on the national strategy on IP, and well, IP is introduced in many policy documents. There is a real interest in building something on it and reaping also, well, fructifying what IP can bring to the market, to the state, to everyone. So there is quite an interest about IP now. Digitalization generally is a trend, obviously, but everywhere, not only in Russia, and it's all about IP administration, but it's also about all the challenges that we get because of the well, online infringement and things like this. And finally, there's also a rising interest towards soft law instruments involving industry self-regulations. There was an anti-piracy memorandum that was also, well, for instance, adopted between the players of the industry. So this is a trend that is also rather interesting to observe. So this is the current state of play. And I let you speak about what happens.
As I told, in Russian Civil Code, we have almost all normal IP tools. I think you have in many other modern countries. Some of them more popular, some of them less popular. For example, trademarks are quite popular, but in Russia it's difficult for now to register, for example, non-standard trademarks, as color trademarks, where just pure color, or sound trademarks, but just standard trademarks are quite popular, and company before launching the product registers the trademark or industrial design. Copyright is also protected, but what I want to highlight that in Russia it's quite high standard of proving copyright ownership in Russian courts. For example, if a company, even a huge corporation, come to the court and say that this design, for example, Adidas, a company very well known, they have cult shoes, maybe easy shoes, and they cannot just come to the court with a printout from the internet saying that, you know, everybody knows it's our design. You need to provide a lot of agreements with authors, how the rights are transferred. And sometimes it's difficult because the company told that it was 50 years ago. These people are not with us, not with the company now. We don't know where they are. The rights are transferred, but by our laws, it's not recorded somewhere. Can we just issue an affidavit? We will say that, to the best of my knowledge, that's like this. And it will rather work in Russian courts. If you just can present the affidavits, Russian courts are quite rigorous in assessing the documents, proving copyright. So this is maybe one particularity of copyright protection in Russia. We also have geographical indications and appellation of origin. Natalia will tell about this later. It's not that popular, unfortunately, now. We also have invention utility models protected by patents, know-how, and plant and animal varieties. Regarding the administrative bodies, we have Patent and Trademark Office. It's Rospatent. It's registered trademark patents, designs, and there is a branch, Chamber for Patent and Trademark Disputes, which considers some of the cases as first instance. We have Roskomnadzor. Roskomnadzor has a lot of functions. One of the function is blocking the website, for example, which where copyright and other IP rights are violated. We have custom authorities. Custom authorities may seize counterfeit on the borders or parallel import and then initiate administrative proceedings. We also have Federal Competition Authority. In IP sphere, it deals mostly with unfair competition. It's not IP, but it's close. Sometimes you cannot say that particular object is infringed, but you see and you feel that it's copied, it's mimicry, and in that case, maybe unfair competition route is preferred one. So Federal Competition Authority is also a body which protects IP in some way. And we have other ministries and agencies. Some of them also deal with IP law. For example, Ministry of Agriculture may issue some opinions on what plant variety or on, for example, some sorts of
animals.
Animals, and whether they are new, whether they are better than before, so to obtain a patent.
Yeah, and the Ministry of Culture is in charge of the copyright policy. So as in France, different ministries are in charge of IP topics, and this is one of the problems as usual is that it's rather fragmented. We can't speak of a unity just because many different bodies have to agree. You see the number of different titles that were granted last year.
You can see how many trademarks and patents are obtained, and that the number of appellation of origins is much lower.
Yeah, Another thing that is different from the French system is that you can, it's not obligatory, it's not mandatory, it's just an option. You can register softwares and databases. Although the right exists from its creation, but it can be used to make it all more transparent and to register licenses as well. Everything can be registered at Rospatent. As for Roskomnadzor, I wanted to say that it's something similar to Arcom, the big regulator that has to be, well, will be created in France as a merger from CSA and Adopi. So it's something that is, it's a regulator in the audiovisual and media and information sector, which has also some of its competences in copyright, online copyright infringement. But as you said, it's a body that is so much more diverse and
yeah, and data protection.
Data protection, yeah, it's a DPA as well. True, right.
Also, apart from administrative bodies, we have courts. So most of the cases, most of the disputes are resolved in pretrial stage or end up in courtrooms. And we have courts of general jurisdiction where all the cases with physical persons, with non-entrepreneurs are considered. And we have commercial courts. It's called arbitrage courts in Russia, where the disputes between commercial entities are considered. We have, since 2013, intellectual property courts. We are very happy because once it was created, court practice on IP became more consistent, more detailed, and the judges there, they don't have all of them to education, but some of them does. And they also can consider patent cases quickly because they're specialists in IP law and maybe in chemistry or in physics. But I know that in Germany, for example, in patent court, all judges are, have both education. In Russian, it's difficult, so it's difficult to find such judges. But intellectual property court is a specialized course, and we can see this. But it's for many cases, for infringement cases, it's just cassation appeal. So you can go there only after having two other instances. Yeah. And we also have Moscow City Court. It's a court from Court of General Jurisdiction branch, but it empowered specifically to consider some types of online infringement to do that faster. We have a special panel of judges there. They know the procedure, and with online IP infringement, they consider them quickly and in a separate proceedings. It's also like 5 years ago was introduced, so it's a development in the judicial branch which show, I think, how IP enforcement is getting better and better in Russia.
Yeah, this intellectual property court is generally a very nice introduction in the system, although the projects were from the 80s and 90s, but it's something that the profession uploads, and they have a very interesting functioning. Yeah, and it makes the whole level of expertise much better. Another thing that we have to mention when we speak about IP in Russia is integration processes. Well, actually, there's one process, one regional integration process that is done inside the Eurasian Economic Union. It is one of the regional integration processes that were that started on the post-USSR, in the post-USSR area. And here they maybe achieved some of the, well, most advanced results, although of course it's not as advanced as the European Union's IP titles. It's something that is less less used, but it has its importance and it has its value. One of the, well, apart from general cooperation on various matters and in the area of customs law, for instance, there is a common customs register of IP objects. Apart from this, we have to underline the Eurasian patent for inventions that was created in 94, sorry, and two smaller titles that will have still to enter into force and to be used in the future: the Eurasian Industrial Design and the Eurasian Distinctive Sign. Well, the conventions were signed, but now we're in the process of ratification. There is also an agreement on collective management for copyright and neighboring rights. I don't know how it works, but there are some. Well, at least it works in the integrational direction. What can I say about the Eurasian patent? It's well, it's a unified patent that can, well, in which 8 countries are participating. So Russia, Azerbaijan, Armenia, Belarus, Kazakhstan, Kyrgyzstan, Tajikistan and Turkmenistan. There is a centralized system of registration. There is a Eurasian patent organization for this. And there is also a centralized administrative invalidity proceeding that can invalidate the patent from the central point. But then the infringement procedures and invalidity procedures for in every member state is in each member state is dealt with by their own courts. So you can also invalidate just a part of this patent in your country, and not so the invalidation in one country will not destroy the whole title. But so it's a mixture of centralized, decentralized. You want to say something?
No, it's just like international trademarks. So it's a procedure which was designed to make the process of obtaining a patent faster.
Yeah. As for well, cooperation with the EU, I can only say that there is only one agreement from 94 as well, in which there is a small IP chapter, but since then nothing changed, and there is still no FTA, as you might know, between Russia and the European Union. So maybe one day there will be something to be said about it. Bilateral cooperation is driven with many countries, and of course Russia is participating in the WTO and also in the WIPO negotiations and standing committees and all the bodies of WIPO, and there is a WIPO office actually in Moscow as well. Well, we know that one of the problems about Russian IP is that you don't get enough information about it, also because it's written in Russian, but well, Google Translator is a very good tool for that if you're, well, or DeepL. DeepL actually works for Russian. First, if you want to get Russian laws and regulations and things like this, you go to WIPO-Lex. I hope you know this tool. It's a very useful tool organized by WIPO. Then Rospatent website, find information there. Main Russian law firms are really active on giving information, providing information on case law. They have newsletters, so if you're interested, don't hesitate to get there. GUR International, which is the German journal now owned by, well, co-organized with Oxford University Press. They are great because they provide translations of decisions from many jurisdictions and from the Russian jurisdiction as well. So this is also a journal where you can find information on Russian law. So we're done with the context, and now we're getting to pharmaceutical.
Yeah, we decided to explain some of the topics in details, to give you a context of what is mostly discussed now in Russia and where we anticipated more changes in the near future. And pharmaceutical sector is one of them in terms of patents. Russia is a huge market, so we have many people, we have main region there, and mostly pharma companies are interested in Russian market, so they come to the market, they patent their inventions, and they want to be assured that the inventions are duly protected and can be enforced. Mostly against generic drugs. As you probably know, but we will recap because it will need it for the future slides. The original drug normally have higher expenses to create because before there is research and development which can take many years and which can result in $1 million for trying to find something, some new vaccine, some new chemical compound, and therefore such inventions are patented, and a manufacturer enjoyed patent protection for 20 years. It's presumed that this 20 years is enough to I don't know how to say, to compensate all of these expenses and to stimulate create further. And therefore, for all of this time of patent protection, actually, manufacturer of original drug is a monopolist on the market, and the drug is of higher price because of higher expenses. Then other companies can, without research and development, just copy the drug because the information is open now, it's patented. And so they don't have research and development, and therefore they have lower expenses, and the drugs, generic drugs, are normally of lower price. But they can only penetrate the market after patent protection expiry. To market the drug, both original and generic, there are 3 steps. So first, we need to conduct bioequivalence study of the drug, is for generic drug with original, then to obtain marketing authorization with Ministry of Healthcare, and some of the drugs are included into the essential drug list, and for them you also need to register maximum price. Normally, generic producers take all of these steps, it's preparatory steps. They take all of these steps 1 or 2 years before originator's patent expiry date. And therefore, originators will home because they know that, okay, my patent will expire soon, and the next day generic can come. Generics are prepared, they have marketing authorization, they have all. However, 4 or 3 years ago, situation changed because generic producers start preparing for coming to the market 5 years before expiry of patent protection. And it's economically unreasonable unless you want to infringe a patent. Because if you're a generic producer and you have marketing authorization, you have price registered already 5 years before patent expiry, if you will not use it for these 5 years, your marketing authorization will be cancelled. And therefore, originators stated that we know that if they do this, they want to come to the market before, and they want to infringe our patents. It was even 10 years ago, but then the court said that preparatory actions are not trademark infringement, not patent infringement. So when infringement takes place, come to us, we will protect you. Why wait-and-see approach is not working? Because if generic comes to the market and infringe patent, you will have litigation in court, which takes about a year. In Russia, unfortunately, preliminary injunctions are rarely granted by Russian courts. So all this year, when you're litigating, these generic products will be on the market and originator will have and will suffer economical losses. Therefore, they had to invent something, and it was a case 4 years ago. The firm where I'm working, we assisted the client in this case. We came to the court and said that it's a not patent infringement, okay, but it's a threat of patent infringement. Because, as I told, it's economically unreasonable with preparatory actions unless you want to infringe patent. And this attempt was successful, so the court decided, it was a lot of expert examinations, a lot of court hearings, but it was quite revolutionary decision because the court told, okay, yes, it's threat of patent infringement, so innovator could obtain permanent injunction for generic drug even before generic came to the market. So innovator did not suffer any economical losses, but as a prevention, obtained this decision. It was important, but generic, they are inventive enough, and they started elaborating new defense strategies, self-defense strategies. For example, they tried to rely on old jurisprudence that it's not infringement, but it's not working in the court. They may file invalidity action against innovator's patent and try to protract the proceedings. They may file for own patent and then try to say that I use my patent, and once it's valid, as long as it's valid, it's not patent infringement. So forcing innovators to go to invalid patent of generic producer first, which also complicates the proceeding and protracts the proceeding. Or what is quite new, filing a compulsory license claim. I will explain a little bit later about this already. And compulsory license is quite new provision in the civil code. So we have different reasons, different situation where a compulsory license can be granted. But before, no one case has been heard on compulsory license. No one compulsory license has been issued by Russian courts. But now generics tried to use dependence compulsory license. So they told that, okay, they before they filed for patent, for own patent, a little bit slightly different than innovators one. Mostly, I don't know, I'm also not a specialist in chemistry, but for example, there is a compound and they say that we do crystallized form of this compound. So it's a particular form of the same compound. And they say that it's dependent. So there are criteria how to assess whether compulsory license may be granted. The first, generics patent should be dependent on innovator's one. It's easy to prove, like I cannot use my invention without infringing yours. Then there are two other criteria which are quite difficult to understand and clearly, and we have no consistent approach of the course and opinion, even in specialists, how they should be assessed. So to obtain compulsory license, a generic producer shall prove that its patent promises important technical achievements. So it's something important. But what does it mean if it make the process of preparation of the drug faster by 5 minutes. It's important. I think no, because it's just 5 minutes. If it promises therapeutical effect, yes, I think it's important, but to what extent? If you just also maybe, I don't know. So it should be assessed on case-by-case basis. And the question is by who it should be assessed. So we need an expert, because the courses normally don't have a medical education or chemical, but it's also in course there are disputes, and a lot of the hearings where parties trying to understand who should be an expert, a person who understands patents or understands, for example, chemistry, or understand chemical technology, because a normal chemist, he may not know how produce the drugs, and maybe technical achievement is in that the drug is produced without one stage or something. The same is with material economical advantages. So generics patents should provide for material economic advantages. What does it mean? Generics say that we are cheaper, but they are cheaper because of they are generic, not because of their patent, just because they didn't do R&D, and therefore they are cheaper. And originators say that you have to prove, if you're a generic company, that your patent is what makes your drug cheaper. For example, your patented technology allows you to skip one part of production process, and therefore you don't spend some money, some people working there, and therefore it's cheaper. And now it's all open question, discussed in a lot of conferences, because as you think that generic have their responses to this question which are beneficial for them, and for innovators there are other questions. Yeah, it's what I told. I had a slide. Yeah, but for judges now, it's very difficult to understand how to resolve these cases. And these cases are resolved not by the IP court, because it's a cassation appeal. So on the first instance, there is just by commercial courts, and the courts are quite stuck with this. And as I can see, they are quite reluctant to be that brave and to issue the decision. They ask how other cases of this kind are resolved, and therefore all of it's protracted. But it's already a year when several cases are pending, and there are compulsory licenses now already which are granted, but these cases are appealed currently, so it's not established practice yet. Yeah, what else is the problem with this? It's that we have bifurcated system, as in Germany, that patent infringement claims are considered by courts. For example, if someone infringes my patent, I come to the court and file patent infringement claim. The court is considering this. And as a common defense strategy, my opponent, he most likely will try to invalidate my patent. And in many jurisdictions, it's considered by the same court in the same case. So it's my argument that my patent is infringed, his argument that it's not valid. But in Russia, my opponent shall go to Chamber for Patent Disputes. This is a separate authority, so it's not court, it's Rospatent Division, and then initiate a separate case. And then these two cases, they can go along, they can go in parallel, or a court, if it consider relevant, he can suspend the case, or Chamber for Patent Dispute can suspend the case, but there is no consistent practice how it should work. And it's, therefore, there is some uncertainty how long it will be, how many investment I need to protect my patent, and it may, I think, discourage patent holders to come to enforce its rights. Yeah, and despite I was quite pessimistic talking about this. It's not be like this. So the as I told, that court considered that early obtaining marketing authorization is threat of patent infringement. It's a good point. So it's a breakthrough. That now compulsory license cases are considered by court. It's also quite good. It's difficult for them to do this. It's difficult for us, for practitioners to advise the clients, because we don't know how the court will assess the case, because we don't have previous practice. And also what we have, what is positive, it's patent linkage initiatives. For example, in Ministry of Healthcare, they have registers in open data on all registered patent, all registered drugs which already obtain marketing authorization, and now they have also the register of pending marketing authorization. So it means that originator can check, can see that something is cooking, so something is pending, and can come to the court earlier saying that it's threat of patent infringement. And also there is some initiatives that to create unified registers of patented pharmacological active substances, about cooperation between Ministry of Healthcare and Rospatents. They also were actively discussed a year ago, before COVID situation, in some conferences, and these initiatives, they are pending now, but I hope that they will be implemented soon. Yeah, that's all for the patent section, patent pharma section, and now it's our last section, I think, about the latest developments. Yeah, it comprises different spheres.
You're right. Thank you very much, Alexandra, and thank you for your actually practice point of view, and well, from on really on a really interesting and area in which usually only specialists go. So now with this roundup of different legislative and case law activities in Russia, I would also wanted to start with patents, just to highlight some of the latest developments, apart from the discussions and proposal that you already described, such as this registry of patented active substances that will be also used in procurement, because of one of the problems is that well, sometimes the generics can already participate in procurement when the patent is not yet expired. And because they have a lower price, they will be upper in the selection for procurement contracts. So this is one of the issues that exist in Russia. Another governmental order just came out recently in the end of November. It proposed to raise the default rules, so between employees and their employers, on how well they will be remunerated for inventions, utility models and industrial designs that will be that are developed during their work as employees. Previously, before this order, there was 1 month's salary supplementary remuneration for new inventions, and now it will be 3 times the average salary of the employee, which is actually quite a nice incentive to innovate and to disclose and well, they don't have a choice but yeah, to do it. You can see just that for inventions it's 3 times, and for designs and utility models it's 2 times more. And there is also another well, incentivations when the invention had been well patented and when it's exploited. 30% of the remuneration is added to the monthly to the remuneration of the employee. Another proposal, something that is a little bit older and which only refers to industrial designs. Well, it's not a proposal, it's already enacted federal law, and it entered into force in June 2019, is the introduction of temporary protection for industrial designs. Well, there was a strong debate inside the fashion industry in Russia that they need more protection, although designs are protected both by copyright and by, of course, some elements by trademarks and some elements by industrial patents, industrial design patents. We have a system that relates very much industrial designs to patents, like in the United States. You also have this design patents and other patents. So after all those debates and awareness raising, what came out of it was a temporary protection element, but in the end it's something that we don't really, well, it's not such a big improvement, let's say so, because it only means that when you apply to the Rospatent to get an industrial design, if you want it, your application will be disclosed before it is examined, before it passes through a substantial examination, and before the design patent is delivered. So it's a way of, well, it's an early disclosure scheme. Well, the bonus is that after the patent is granted and after you sue for infringement, you get more compensation. The compensation awards is higher because you also get compensation for the time that your design was infringed, though it was disclosed. But maybe you know that, for instance, in France, one of the most, well, the way the fashion industry is using design protection is they very much use the non-disclosure, ajournement, this non-divulgation processes. So here it's quite, we don't know how this mechanism will be used, whether it will be used a lot. And if you want to, you were saying there's also a question whether, I don't know if you want to add, Alexandra is also she's not only a specialist in patent infringement, but she's also a specialist in fashion law, and it's one of the Russian specialists in fashion law.
More specialty. This law was really discussed. It was announced that it will help fashion industry, but the fashion industry didn't want it to be enacted because it can promise the benefits Natalia told, but it also have some room to abuse this right. For example, as we discussed with Natalia recently, I can be quite cunning, and for example, I'm a designer and I file an application to a patent office saying that polka dot, it's my design, and it should be registered in my name. And it's disclosed, and from this I can start sending warning letters to other companies, like, I don't have patent for polka dot now, but maybe I will in 3 months, in 4 months. And if I obtain patent, you will have to pay compensation after the period and for this period, for this when my application was pending. And other companies, they can understand that it's strange, so you cannot monopolize polka dot. So the Rospatent, they are not idiots, so they probably will issue a refusal decision. However, to be on the safe side, they may think that, okay, who knows? Maybe Rospatent will don't know polka dot who work there, and they may be reluctant to come to the market in this season. For example, with dresses with polka dots. So this person who applied in Malahide, they will enjoy maybe using the most fashionable print for some period of time.
And it's enough for
then he received a refusal, but for example, summer, he will be the only one in the market who used, I don't know, stripes or polka dot or
little hearts or I don't know what.
Or something. Yeah, and therefore we don't know. It's just imagination. It's from discussion within the industry how it can be enforced by some unfair companies. Yeah, but we don't know. Actually, the law is enacted already for the whole year. Maybe it's used by someone, but actually I don't know whether there are any huge cases, like discussed cases. Maybe there are some cases. Yeah, we'll see.
We'll see in the future. Well, another introduction. Yes, we'll have some images after that. Another legislative development of this year is the introduction of a second type of geographical indication in the Russian IP system, and it's something that you know in the EU for quite some time, in France even more, and in the EU you have other types of protections as well. Well, not protection, but at least signs in this general geographical source protection scheme. So, well, we wanted to start from saying that appellations of origin are protected in Russia. But as of August 2020, there were only 240 appellations of origins, and today there are 253. The last one was registered in November. It was a Krasnodar strawberry. And as you see, not so many people are using this system also from abroad. Only 41 foreign, valid AOs were registered. And if we look at the types of production of products, well, strikingly for me, the most popular good was mineral waters. This is something that is very much protected by GI, well, not GIs, but AOs in Russia, appellations of origin. Crofts are also something that are protected. And you know that at the EU level, crofts are still not protected by geographical indications, but in France it is. Well, food, alcohols, different types of alcohols are protected, but only 10, so it's not something very common.
It's not like French wine.
Yeah. Although you will see that vin de Provence is protected in Russia. So starting from July 2020, there is this additional geographical indication which protects well, the link between a designation and the quality, reputation, and other features of a product that are significantly linked to the geographic origin of this good. You will see later the differences between the two, but in order to say it simply, it's as in Europe, you have lighter protection requirements for geographical indications. You have a lesser protection link between the territory, the terroir, and the good itself. In the same time, you have same protection between the two types of titles, which is, well, a limited, as you know, exclusive right, because you can't sell your title. It's something that is, well, you know, all the intricacies, public intricacies of a geographical indication, of the indication of a geographical source. Well, the protection is against the use of the same name sign, but also imitation type source of the same goods and geographical things. The certificate is given for 10 years. And then when renewing the certificate, you have to prove again, well, that the object has not lost its specific features. The introduction of this new type of geographical indication is meant to also pave the way to the future accession to the Geneva Act of the Lisbon Treaty, and also to facilitate protection of, well, Russian GIs abroad and foreign GIs in Russia. Here are some images so that we relax a little bit. Those are crafts. Rostov-Neft is an enamel on metal. It's a very, well, an old craft. I don't know if it's an old craft. Yeah. Filigree, metal work of Krasnoselsk, which is a beautiful one. Hochelaman, maybe you know it. It's very popular abroad. As for the foods, comté cheese is protected in Russia. We don't see it much now because of the contraceptions, but it is protected. For those in Strasbourg, pretzel are not only produced in Strasbourg and in Munich, they are also produced in Viborg, which is a city on the boundary, well, it's very close to St. Petersburg, but it's even closer to Finland. And there was a production of Finnish kringles there since the 16th century. So there is apparently even a festival of kringles in Viborg. The look of its cucumbers also have a very distinct shape, taste, and well, other specific features. So it's an appellation of origin. Beverages, wines of abroad you saw. It's our sparkling wine, which was called champagne until recently, but now, well, it's called sparkling wine. Gurjani, Georgian wine. Côte de Provence is protected, and as you see, many different waters. When we were saying that AOs are difficult to get, one example is what happened to the Napa Valley wines when they tried to get a protection by filing an application at Rospatent. They filed it in 2013. It was rejected. Then the appeal was also rejected. And Rospatent said, well, the problem is that this appellation of origin, what you want, this application for an appellation of origin, is not based on the same type of IP protection in the United States. In the United States, it was protected by a mark, a certification mark. As you know, GIs are very differently protected in many different countries, and well, you also have this differences between the EU and the US based on what is protected by a certificate mark or a collective mark, and what is protected by an AO or a GI. The IP court then annulled the decision of the Rospatent, saying that it's not necessary to have an appellation of origin title abroad, but it's sufficient to have an equivalent protection to an AO. And it remanded the case back to Rospatent. The problem is that after that, Rospatent rejected this application again, because in 2013, when Napa Valley applied, they didn't yet have a certification mark in America. They had other documents, but they even didn't have a valid certification mark. So this application was rejected. And one of the first applicants of the new law introducing geographical indications was, of course, Napa Valley wines. So
yeah, quite stubborn.
After
3 years, 2 rounds of Rospatent and courts, they still wanted.
But they are drunk here. So, yeah. So the main differences between appellations of origins and geographical indications, I think you know them from the French and EU law, but here are the basics that we will just to have a different, or to have a general overview about it. Appellations of the origins are only given to a verbal sign, a name, but geographical indications will be given also to other sorts of designations which can identify a product as originating from a territory, geographical location. So it's already a big difference. The specific features of a good should be exclusively or essentially defined by the environmental and human factors for AOs, and only quality, reputation, and characteristics have to be significantly due to their origin in GIs. Of course, one of the most difficult requirements is to have all the phases of a goods production made in one territory for appellations of origins. And in GIs, you need to have only one phase of the production at the territory for which the geographical indication is claimed. Another important difference is, although both titles are protected through a registration system at the Rospatent, in order to get an appellation of origin, you have to have an opinion from a competent authority, which is either federal or local. Well, it's defined in decrees, but you have to have a first checkup by a competent authority. Although if you apply for geographical indication, the onus of proof is on you. On the applicant, on the association that applies, on the person who applies, so they can more or less bring everything they want. The name must be well known already at the registration for appellations of origin. And as for geographical indications, there is no such requirement. So I can actually say that, I don't know, my tea produced in my backyard is something, has its geographical, has some specific features, so it's enough for protection. And maybe one of the most important features that you will be interested in as foreign applicants, possible future foreign applicants, is that for appellations of origin, now it's written in the law that you have to show an appellation of origin title in your country of origin. And for GIs, you see that it can be a GI or another distinctive sign, which is why we hope all well to Napa Valley wines.
Yeah.
They get protected in Russia.
Good luck to them.
Good luck to them. Yeah, and you were explaining to me, Alexandra, well, when we were discussing this thing, that it's really difficult to get an appellation of origin.
Yeah, as far as I know, it's difficult. Personally, I haven't tried to register something, but from other people, we know that it's difficult. Sometimes you can see that there is an appellation of origin registered already in the name of someone for one company, for example, and other company, for example, it's Baikal water. So it's water from Baikal. Baikal is a huge lake, and different companies working from different sites of Baikal and producing water using the water from Baikal. And for example, one company already have appellation of origin, the name Baikal, and the other company, they cannot register another one. They can just join this appellation of origin, but they need to prove to Rospaten that my water is the same, so it has the same significant features. And these significant features normally should be reflected in Rospaten's register. So we have register, you can see number 1, Baikal water, and then it should be distinctive signs, features listed there. For some appellation of origins, they are listed. For some, they are not listed, especially for the old ones. And if I want to join, I call Rospaten and say how to do this, how I can check whether my product is compliant with this. May I join? And they told that, no, we cannot say this information to you. And we say, okay, maybe we can just file some inquiry, because how can we join? And it's a strange problem. I heard about this, but it's more technical problem and problem of misunderstanding between the part and some disorganizing here. But I think maybe this bad example of Napa Valley and some of these rumors that that's difficult to obtain protection was the reason why there were few appellation of origins, and therefore maybe geographical indications appear now in civil code because it was not popular. And we hope that probably it will be improved in the next future, and the court practice will develop in this regard.
Yeah, so we'll see, because it's many things have still to be well put in practice, and yeah, well, next year we'll tell you more about case law, maybe, or at least the Rospaten practice. Well-known trademarks.
Yeah, well-known trademarks is also something which should be beneficial for companies, but in Russia, not that popular. And as you can see, in Russia, there are more than 146 million consumers, and we have more than 500 valid marks, and only 215 of them are registered as well-known marks. And to be well-known, to obtain this status in Russia, we need to go to Rospatent. It's a special proceeding, so we need to file an application. It will be the case, and we will present in the hearings and try to prove to Rospatent with many documents that our trademark is well-known. Then Rospatent, if Rospatent decides that, okay, you are well-known, we will have this well-known protection, which is beneficial because it can be extended to non-similar goods and services, but not all of them. So it still should be similar, because consumers should think that it may be you. But when you are very known, your mark is well known, other things consider it. For example, it's Coca-Cola. Coca-Cola is quite well known, and if you see chair where Coca-Cola written, I think people think that probably it's Coca-Cola. Maybe it's collaboration with Coca-Cola, because Coca-Cola have many things. And well-known production is timeless, so you don't need to prolong it here. However, it's not that popular, so as you can see, not many designations are registered, because Rospatent have quite a strict approach. Rospatent really think that you should be very well known in the whole territory of Russia, and it can be difficult because Russia is a huge country. We have different regions, and some companies, they may work only in some of the regions, and they may be very popular and known by everyone in Moscow, in St. Petersburg, in the eastern part in Russia, but not now in the western part. For example, we have McDonald's only on each metro station in metro, and everybody, I think, know McDonald's in Moscow, in St. Petersburg, in many other cities, but McDonald's is not operating in Far East. I don't know why, but there are, maybe it's expensive to control this region or something, but there is part of Russia where McDonald's is not present. Maybe people know McDonald's from movies, from something, but
difficult to prove.
Yeah, it's difficult to prove, and it's not certain how Rospatent will assess this, because it was the case with logo of St. Petersburg Metro. It's quite special. It's M-word, but executed in stylized font. It's blue one. It's known for St. Petersburg people because they use metro. It's known for us because Moscow is quite close and
we go there, but
but maybe not for all Russia. Maybe, and it's also difficult. I don't know. I don't remember. It was not prepared, this case, for the presentation. It just came to my mind now. I don't remember whether it was it obtained.
It was obtained.
The St.
Petersburg was obtained. Right.
Yeah, but it was a question like, okay, you are well known in St. Petersburg, but in other places, and also. What is should be proved that it's among relevant consumers, and if consumer know this mark, but they cannot say who is producer, it can be a problem because the mark can be very well known. For example, the same Coca-Cola. We know that it's Coca-Cola company, but there are other brands. I can say like which.
Raffaello was one of those cases. Is the IP, well, the right is applied for by Martech, which is a company registered in Belgium or Luxembourg, and which operates IP rights for the whole. What's the main brand of Raffaello is?
Ferrero.
Yeah. So the Ferrero and Martech are not the same legal person. They are affiliated. But the problem is to prove that among relevant consumers, Raffaello, this cocoa sweets, that they are well known as coming from Martech.
Because people know it. You know Raffaello? Yes, I know Raffaello. Who produced Raffaello? Rafaela Ferreira,
Yeah.
but not Sarmatek. So, and to prove this, you need to normally to provide a public opinion survey. It's done for more than 2,000 people, and they are asked this question, like, you know the product, and you know whether it come from which company. And if your company is not known to the consumers, it also can be the problem.
But we see this year has been, well, there have been several cases in which the rejections of such well-known trademarks by Rospatent were overruled by the IPC, so the IP court. And in several instances, the Supreme Court also supported the decisions of the Presidium of the IPC. There's one case that is now pending at the Supreme Court, and we're waiting for the results if it goes to a hearing. But for the moment, we can see that there is a trend towards easing this requirement of the link between the applicant's good, between the applicant as a source of origin and the well-known character of the trademark. There is another requirement that is also eased in the Rafael ruling that I will not discuss now. Well, this is a very general scheme just to show you what we just said. Doshirac, I think it's not sold in France under this trademarks treatment, but in Russia, all the students, everyone knows it's instant noodles that are eaten everywhere, and there are lots of promotion on this, not lots of advertising. And so the application for this well-known trademark was filed by Paldo, which is a global Korean company. But the problem is no one knows in Russia what Paldo is. And that's why Rospatent refused to consider this trademark to be well known, although it said that everyone knows, and that the companies, Doshirac is also, there are several affiliated companies that even produce it in Russia, and many people, well, are attracted to these goods. So the IP court appeal, well, where the decision of the Rospatent was appealed, it says no, it is a well-known trademark because you don't have to prove that the consumer knows the applicant, but you have to show that well, as a source of origin, well, that it's the same source of origin. Say the function of the trademark has to be accomplished. The Presidium of the IP Court also endorsed this decision, saying that it's not also sufficient to say that the applicant doesn't have to be known, but we really have to go back to this idea of source of origin. And now, well, the case is before the Supreme Court, and I don't know whether we don't know whether there will be any progress, or maybe we will stay with this position of the Presidium of the IP Court, which will be the same as what happened in the Martin case and in the Avito case. Avito is Le Bon Coin in Russia. It's very, very much known, but the applicant was a Swedish legal person, and no one knows this legal person. So very quickly, because we have to advance actually, on copyright, two things that I wanted to underline. Since October 1st, there is a new piece of legislation enacted and, well, in force, which permits to, enforce in a swift way copyright when the infringement is done on mobile phones through a mobile app. I will show you the scheme very quickly. And next year, there will possibly be further discussions and further enactment of an additional mechanism to enforce copyright online, which will help delist links to, well, infringing websites from search engines, because in general, although, well, there are lots of problems, but the mechanism of copyright enforcement online is quite well settled and established and it works, then of course new websites appear every day. So it's not, it's a course vers la montre. It's something that is difficult to enforce durably because of the technological advancement. Although there are also this eternal blockings that exist. Whatever. So one of the issues that are now existing in the industry is to oblige search engines to delist hyperlinks, well, links to illegal, to the website with illegal contents. It's something that was dealt through by this anti-piracy memorandum I was talking from the beginning, in 2019, in 2020, and it's extended until 21, only for some works. Not all the works are dealt with under this memorandum. So we'll see, maybe there will be something next year, maybe not. We actually don't know, maybe this memorandum will just keep going on. So for the mobile apps, well, the idea is again to enforce quickly copyright rights against distribution of illegal access to copyrighted content that is available through apps on your mobile phones, because everyone watches or listens to music or watches videos on their phones. All copyright works are targeted here, except for photos, because it's too much difficult to enforce. Well, you have another analysis to be dealt. Well, there are other difficulties, let's say, with photos, and the whole thing is to actually first use, well, and the Roskomnadzor really pushes all the parties to use pre-trial, extra trial settlements, of course, and mainly the main part of the cases will be resolved this way. But if it doesn't work and if there is still infringement, then copyright holders have to go to the court to get a decision on infringement. It can be a preliminary decision. You don't have to wait until the last certain decision on infringement. Then the holder notifies Roskomnadzor. Roskomnadzor notifies the marketplace, so App Store or Huawei Gallery or what are the others? Google Play, who has 1 working day to notify the app's owner, who then has to block the content, to block the access to the illegal content. And if it doesn't happen, if the app's owner doesn't block the content, then the App Store has to do it. And then if the App Store doesn't do it, then Roskomnadzor goes to the telecom provider, to the telecom operator, which then can block so much more than just a little application. So we don't know how it will be used, whether it will be used a lot or whether mostly it will be used, well, the infringements will be cut at the pre-trial time or at the moment of the court's proceedings. But at least this mechanism exists now, so we'll see how it will be used and whether it will be efficient. Obviously, as in any online copyright proceedings, the issue of overblocking is present, and it's something that we have to worry about. We'll see how it works. For the moment, there were no, there's nothing in the press, so I don't know whether there was any any terrible blocking by telecom operator of all the apps, of all App Store. It didn't happen for the moment, so we'll see how it all evolves. And now evidence and other issues.
Yeah, and it's not issue. Okay. It's a topic. It's a good part. So it's something positive. Supreme Court, which is the highest court in Russia, it's higher than IP court, so it's the highest court of all courts. They sometimes issue guidelines on some topics, and last year they issued guidelines for resolving IP cases.
pages long.
Yeah, it's a huge, so it explains many particularities of how the High Court, it's summary of the practice, and it answers some questions which were disputable in the industry. So it's a good document. We are happy having this in place, but what I want to highlight especially that it makes our lives easier, because for example now we can prove something with screenshot. For example, if I need to that this logo is on this website, it was there, I can just print out. It should be date and time, and the link to the source, like www. dot something, and bring this to the court. And now it's admissible evidence, because before the court, it was not written somewhere that it's not admissible, but the practice was that you need to provide the court only with notarized documents. And it can be expensive for, especially not for companies, but for physical persons. Maybe if I'm an artist and I think that someone infringe my rights and I need to go to notary, it's also time-consuming process. Yeah, and now it can be just as printout. So before it was a concern that what if I rectified something in Paint, but now I can bring screenshot. Normally it will be accessible, but if my opponent thinks that I corrected something, it can file falsification of evidence motion, and the court will more meticulously check whether this is falsified or not. So now it's easier to prove something. Also, it was a question, for example, if I do test purchase and I want to show that in this shop there are logo somewhere in design of the shop, and I bought, for example, I know this Mac and this, my logo is there, and if I recorded all this and bring this to court, some courts, they are rejected. They reject this evidence, saying that there are other people there. They are, they haven't known that they are recorded at that time. They were recorded, and it violates privacy. It was that argument, and sometimes such evidence was rejected. But now the court clearly stated that it's not privacy, it's not personal life, it's someone working in a shop assistant, it sells something. Yes, he didn't knew that he was recorded at that moment, but nothing bad happened, so you can use this as an evidence of IP infringement. It's also quite good. Also, the trend is digitalization, as we told, and this COVID and pandemic situation where we locked in our flats now was incentive to I know,
drive digitalization in.
Yeah, because before we had online filings in Rospatent, it was an option, and we know that it is, but we were even lazy to try, and we use paperwork. But now every patent attorney knows how to do online filings. We have online filings of procedural documents almost to all courts. It's also a centralized system. It's easy to use, and what is new and like 2 or 3 months ago was implemented, that we can familiarize ourselves with the case. Yeah, it's not my Russian accent. after an hour and a half, we can see the case documents.
Yes.
Provided by other parties in electronic format. So before we had to go to the court to see all these documents, to take photos of them. But now if the documents were filed electronically, we can just send a motion, and the court can give us an access to these documents, it's great. Absolutely. And we have online hearings in course. It was due to pandemic situation, and it was before, but now it's more popular, and it reduces travel costs for all participants. And we have online hearing in Chamber for Patent Dispute, and it also existed before. Because Chamber for Patent Disputes, it's only in Moscow, yeah, and people from other regions, it's difficult to come because you have not only one hearing, yeah, but they have limited capacity, so they have only one room, and you need to book it in advance if you want. But still, now we worked online and attended the hearing and see the court documents for 3 months without going somewhere. And it was something I had not been thinking that it could be possible before. Yeah, also what is new, it's the last slide, I think, from our presentation, is that Chamber for Patent and Trademark Dispute enacted new rules, how they consider cases. They had old rules. They were enacted 15 years ago, or maybe even more. Yeah, so we cannot see the terms, but okay. So the main idea is that now it's easier and faster to consider, for example, trademark cancellation case or patent invalidity case, and parties are more free during the proceeding. Before, you have to file all you want to file, and then you cannot file additional documents during the proceedings. It was super strange because maybe some great idea came to your mind, maybe opponent said something and you want to disprove this, but you were tied with the argument you presented with your application. Yeah, now Chamber of Patent Dispute, it's in Rospatent, so they have technical education. They may not have legal education, but most of them have special technical education. Before, they consider the cases by their own, but they're also not specialists in all spheres. Now they can invite outside experts if there is something they don't know from technical point of view. Yeah, so we know. Yeah, we told all we wish to share with you. We know that you are not specialist in Russian law, but we are very pleased that you are interested in it, and we hope that maybe something of we told will help you somewhere. And if you are interested in Russian law, we suggest you to follow latest trend, because it's all changing quite rapidly. Yeah,
and because of the COVID specifically, as you said, the practices are changing as well. And I wanted actually to say, not only Rospatent did change these invalidity procedures, but it also accelerated the procedures of granting products.
Yeah,
you will see it in the Rospatent last year's report that it's going very fast now, and the examination goes quicker now. And another thing that I wanted to ask, just before I forget it, is that in this resolution of April 2019 you were talking about, one of the things that were observed by practitioners and everyone was that in many cases, the position of the IP court was endorsed by the Supreme Court's plenary session. So it shows how consistent case law is becoming because of the introduction of this of the specialist court, and it's actually something good to see, and it's a valuable addition to the IP protection system in Russia. So yeah, be aware.
And we tried to be objective. So we told you about the new initiative, the promising initiative, but we also tried to explain that maybe some drawbacks in them, something we need to think further. But summarizing, personally, I really working with Russian IP law more than 6 years. As a practitioner, I see how all these trends, IP course, new guidelines, online digitalization make the Russian IP law easier to enforce and make companies and inventors are more, I don't know, protected, yeah, and feeling that their rights are protected and can be enforced. And that is good, and we hope
that is not bad. Yeah, that's good for the IP institution in general. So now we're really ready to get your questions and comments. Well, if you still have some questions and you don't dare asking now, you can find our emails and send it later.
I've seen that there were questions,
but I think Anaïs and Louise and Gabrielle will read them.
Oh, okay.
So now you have the floor. You have the floor back, and thank you for listening. Actually,
thank you for your presentation, and we would also like to thank you, Mr. Debled, the Director of the International Section at the CEIPI, for joining us. So if you'd like to give a little word, and then we'll move to the questions. So if you have any, don't hesitate to ask anything.
So thank you very much, Anaïs and Elodie, for giving you the floor. So first, for having invited me. I have to say that the presentation was absolutely interesting, really amazing. You have spoken for more than 1 hour and 40 minutes, and for me, it's as if you have started just 5 minutes ago. You have provided us with a very interesting overview of the whole the Russian IP system, which involves absolutely many different aspects, and so that's why you have been obliged to be very superficial, but I'm sure that now by answering the questions, we will arrive to something, well, you will fine-tune some of these elements. And well, after you will have exhausted the list of questions, I might have some further questions for you.
Okay, thank you.
Maybe we will get out of this presentation mode and we'll see. Yeah, does everyone agree?
Yeah, so we're gonna move to the questions.
Oh yeah, we can read them actually.
Yes, yes, yes.
You're right. Where's my clicker?
The first one is about the slides, if it's possible to have them, so then we can maybe share them to the participants.
Yeah, of course, we will send you the slides. Yep, is it fine by you?
Yeah, sure.
Of course.
Yeah, yeah.
We have to, maybe I will correct some typos and
yeah, awesome.
And add our emails.
Yeah, the first question is mine.
Yeah.
Is programs protected by IP in Russia? It was topic on which I need to write an article, but I'm a little bit lazy. It's interesting. Fragments cannot be protected in Russia as invention, because invention protects something important for society, like drugs, like invention of new production process, and fragrance producer, they therefore cannot protect the scent.
Scent, yeah, the smell.
Yeah, I know how it's the smell, but also there are other mechanisms which are normally working. I once spoke with LVMH brand protection lawyer, and they told that, for example, he liked Dior. It's a fragrance.
J'adore. For those who...
Yeah, my French is not that good.
Oh, no.
J'adore. But there are maybe counterfeit in the market. There may be something which smells the same. But I think for most of us, we will not buy it because it will be in different bottle. It will be named differently. Because if it's named Dior, you can prohibit this by trademark protection, by unfair competition. If it's the same bottle, a bottle can be protected by industrial design if it's original enough, for example, as Dior. So you can prohibit using similar bottle, and therefore this infringer, they will just walk and it's the same smell, but nobody will buy this. And therefore, fragrance is not protected as patent, but all other tools which a company may use to protect its brands, its name, its bottle, normally are sufficient to protect to protect the product from blatant copying and to have your consumers not going somewhere to counterfeit products.
But the smell itself is not protected, in Russia, as in France, actually. Well, there's a question about the DMCA in the United States, that it is a huge program for live streamers and content creators because it provides them from using music either during their streams or in their videos. How is it handled in Russia? Well, from my experience, and I didn't try to enforce anything in Russia for the moment, what I wanted to say is that maybe the absence of an act, sorry, I start again. The system of enforcing copyright online is very reactive active in Russia. It works. The problem is, of course, there is overblocking, and very often it is described as not sufficiently aware, not sufficiently protective of others' rights or others' freedoms, and it's it's the same problem as in the United States. During the championship, many sports live streams were blocked, and it worked apparently, but yeah, I don't know what to say. The audiovisual companies and music companies are all asking for better protection, and content creators and live streams don't have the power to go see the legislators to actually to ease the protection that is given. But there are some elements in which the Russian, for instance, the absence of mandatory mechanism against for delisting links that now exist only for audiovisual works based on an agreement between different players of the industry. The fact that it's not an act, that it's not law now, well, it shows that there are reactions against the mechanisms in Russia, and you have lots of NGOs, and you have people who are vocal against overblocking and against too strong protection, of course. And actually, I also have to add that DMCA applies in Russia as to when you use when content has to be appears in Google, then you use their form, and well, Russian law will mostly apply to Yandex, Rambler, and those operators that are Russian. Yeah. Do you want to add anything?
I can add from another point. In the United States, there is some, as far as I know, how we call it, fair use exemption, and it's not formulated as list of exemption from copyright protection. So it's more criteria, and the court can decide on the case-by-case basis whether it's fair use. And for example, if I use just part of the music in my just private video where I'm dancing at home, if it's not creates economical losses for universal music, for example, as far as I know, in the United States, it will be allowed. It will be covered by fair use, yeah. But in Russia, we have also exemptions from copyright protection, but it's limited lists of exemptions, and it's a little bit more difficult sometimes to prove that your activity as a streamer covered by these exemptions. For example, I can use others copyrighted materials for educational purpose or to illustrate something. I can have maybe I just have this presentation, and we if it's about movies, I can show you some parts of the movies, like 1 minute, but it's saying that, look at this, and now I will explain why she's wearing red dress there. But in that case, I have to prove that it's not so that it was done with illustrative purpose, so it's not more than I need to illustrate, and it also can be difficult, like why don't you show just 1 second and you show 1 minute, and it's also not established. And therefore, I think maybe in the United States, sometimes for content creators and live streamers, it's even easier to reboot these claims from huge companies, and in Russia it's maybe a little bit more difficult even because of this.
Yeah. Although I have to say that the list of exceptions and limitations in the Russian IP code is sometimes more extensive. Well, it's sometimes bigger than what we have in France. For instance, the panorama exception existed for quite some time. There are some differences if you want to analyze it. There are some other things that are authorized clearly in Russia that are maybe not so clearly authorized in France. Have to check and compare it. So what are the other questions? As part of an emerging market, what about wine, spirit brands, and geographical indications in Russia? I didn't say that, but this law of July, well, which entered into force in July 2020, it also introduced some changes into wine geographical indications in Russia. And I'm not ready to speak about it now, but there is a strong interest in protecting and protecting and evaluating, not only protecting these wine brands, since Russia recently got another region where wine production is very active in the south. So there are things that are done in this area, but I think you will have to ask a specialist on wines and spirits. I'm sorry, I will raise my joker tonight for that.
Yeah, another question, can the bottle be protected by a three-dimensional trademark? Yes, it can be. As I told before, standard trademark, by standard, I mean like word trademark, graphical trademark, device trademark, or combination. They are more popular, but three-dimensional marks may be protected. I have seen such trademark, and I even seen such bottles, but it should be very, very original bottles. So it's just, if it's just bottle for beer and maybe a little bit more, I don't know, wider than the normal bottle, it will not probably receive trademark protection, because Rospatent will say that it's not a trademark. So it's not, it's something more practical. Other companies should use it also. So it's not
functional,
yeah,
or not distinctive.
Not distinctive. But if it's more original bottle, it can be protected, but also the company should prove to Rospatent that people understand, that they perceive this form as the bottle of this company. So they perceive the bottle as a trademark.
As an origin of...
Yeah, I'm trying to think of an example of original bottles, but I don't know actually.
Well,
well, yeah, but it's not about, like this. So it's bottle not of wine or maybe something.
I don't know, but yeah.
Have
to check. Well, as in EU, it's difficult to protect three-dimensional trademarks, but it is possible.
The same in Russia. So it's possible, but it's not very popular and it's complicated.
And the last question is a tough one. It's about the Unified Patent Court and the fact that the Bundestag has re-voted on it recently. Maybe an agreement will come. You know, every year we say that next year there will be Unified Patent Court. So the question is whether the evolution of Europe towards Unified Patent Court will impact Russian IP, and if yes, in what sense? I wanted to ask Thierry Debled to actually answer this question, because you are the specialist in patents, and you know so much more about the UPC. I think just as a small thing that I can say, Russian patent activity abroad is not as important as the Chinese or the American activity. So, well, if the unified patent makes it cheaper to get a patent in the EU, yes, it will be simpler for Russian applicants from Russia to get one. But then there are not so many Russian inventors. I mean, the big companies that are using patents in international forums, they are not Russians, I'm sorry to say. So the impact of the UPC will not be as important as it will be for other countries. But maybe I'm wrong. Maybe there is.
No, I think the same.
Yeah. Well, we can say that it's a positive impact because it will be cheaper to get patents in Europe.
Maybe Russian startup will now think that it's too
expensive to get
one.
But it will all depend on the case-by-case situations, and we still have to wait whether the agreement will get into will enter into force.
Yeah.
Okay, then if you allow me, I have actually I have two questions, but as it is quite already late, it's about 9 p.m. for you in Moscow, so we don't want to take you out of your dinner for that long. So maybe you can decide to answer one of the two questions. The first question is about patent term extension, what we call SPC in Europe. Mm-hmm. Do you have that in Russia, and how do you use it? And the second question is about exhaustion of rights. Mm-hmm. So how does it work in Russia? Do you have a kind of exhaustion of rights valid for all the CIS countries or just for Russia?
Yeah, I can answer both questions. Yeah. For CPC, we have this, we also can prolong the term of the patent, but it's a little bit different from the European Union. We don't have, for example, CPC for orphan drugs, and I know that in Europe it's possible. We can, a company can obtain CPC, patent supplementary certificate for patents only related to pharmaceuticals and to agricultural things, which requires marketing authorization or other protection if these administrative proceedings, for example, obtaining marketing authorizations, was too long. If it was too long, you cannot use your patent, not because it was not your fault, it was fault of Patent or Ministry of Agriculture, and therefore you can obtain the protection, additional protection for this period you suffered from these protracted proceedings. Yeah, it's possible. It's easy. So many pharmaceutical companies use this instrument, but it only for drugs and for agricultural things, and it's the same for all drugs. So no additional protection, for example, for orphan drugs. So the period is the same. And regarding the exhaustion of the rights, we have national system and regional, but not for CIS countries, because CIS is not some union, it's more just a common
political area,
like name for the post-Soviet countries, but we have European Union.
European Economic Union.
Eurasian Economic Union, as Natalia told, and there we have regional principle of exhaustion of the rights, but not global one. So, for example, if a product is placed to the market in France by its producer, but someone imports it to Russia, it's parallel import. So it's a regional product, not counterfeit, but if company has not given its consent for this, it will be prohibited as parallel import, gray import is prohibited in Russia. And so it's infringement. But recently, 2 years ago, we also had, we received a decision from Constitutional Court. It was very important and also widely discussed, because before, counterfeit good and this parallel imported good were treated the same in terms of compensation obtained by, for example, trademark owners, and this parallel import could be destroyed the same as counterfeit goods. And Constitutional Court decided the case and told that no, yes, they are still, it's still infringement, it's still trademark infringement, but it's original good, you cannot destroy it as counterfeit good. And the compensation should be lower, because economical losses from counterfeit are much higher from normally than economical losses arising out of parallel import. But if you want to have compensation, but by default, so it's, you can go to the court and say that from this parallel import I suffered a lot and show this, and you can obtain a high sum of compensation, but now it's more complicated also. And I think it's fair, so it's wise to divide these things. So yeah.
So first you have to check whether the products were real fakes or originals through parallel import, and it still will be an infringement, but the compensation and the destruction measures will not be the same in these two different situations.
Yeah.
There is another question.
Yeah, I've seen it. It's very interesting. Do you think that existence of both GI and appellation of origin might confuse the ordinary entrepreneur?
The ordinary entrepreneur or the ordinary consumer? That's the question. Well,
I think for someone who wants to obtain this protection.
Yeah.
So
well, I think it will be, because GIs will be so simple to obtain. Simple, we don't know whether it will be simple. It will be, now it's simpler, then we'll see how the practice goes. It will be better for the entrepreneur to get it, and then we'll have to see the practice of differentiation that will appear through infringement proceedings, etc. Whether it will be more interesting to get a GI or an appellation of origin. So this will be another factor that will have to be taken into account. Yeah, so I think there will, for the moment, there will be no confusions. The whole thing is to make entrepreneurs get at least something, at least one of those protections, and the whole policy is towards more titles. So
this patent is quite active in
explaining things.
Yeah, in explaining what is new and what it can, what benefits it can bring to the company. And I think it's Rus patent task to explain also to startups, to entrepreneurs, which not a corporation with patent attorneys inside, what instrument in Russia they have and what benefits they can bring to them.
Yeah, so for entrepreneurs, it's not a problem yet, and then we'll see through practice what it will bring. And for the average consumer, I'm not sure there will be anyhow impacted actually now, because, well, they know that those cucumbers are important. They will buy them, not because there is a stamp of geographical indication, but just because of the name of it. So yeah, this is the answer. Are there any other questions?
There is actually some question in the chat. The first one is, in which direction do you think Russian IP regulation will primarily develop in the near future?
Can you speak louder? Sorry.
Oh, sorry. So, in which directions do you think Russian IP regulation will primarily develop in the near future, next 4 or 5 years?
I think one of direction is, for example, for patent linkage system, because it's discussed a lot. And for enforcement, I hope it should be more easier. For example, we before we had accelerated procedure for online IP copyright enforcement. Then 2 years post, and now we see that they may be not just only online on the website, but only in mobile applications. And some times ago, we received a law on blocking of this in mobile applications. So if there will be new also digital challenges, the Russian legislative, I think, will also react on this.
Generally speaking, if I may, is that you know that the situation economically is not the best now. It wasn't the best since 2014 already, after sanctions, counter sanctions, and all the economic turmoil and relations between the EU and Russia and other countries as well, plus the COVID times. So I would say that the instruments are already there in terms of legislation. Now we have to see how it works in practice, and IP rights will work when there will be economic growth. And this is something very important. So maybe the general trends will be less in legislation in IP, but more in helping entrepreneurs and helping the market to actually work and the economic benefits to come back. I know that there was also discussions about better fiscal regime, tax regime for IP exploitation, and you know, things like this around the IP rights per se that have to be to get stronger.
Yeah,
So
but all of these are fragmentary also. We don't know about any planned revolutionary reform in IP protection.
There will be the national strategy that will come up, but it will be a
so
policy
not
document.
new civil court is expected in just near future, but just some areas for development we told about, and there are and in this direction, I think the Russian legislative body and the courts will work further.
Yeah, that will be all.
So thank you very much for your question, your answers. I suppose we have no more questions here. Now I believe our conference is over, and now it is the point when we have to thank all our participants for joining us, and our distinguished speakers, Natalia and Alexandra, for giving us such a broad and informative overview of Russian IP law. As we see today, most important issues are related with digitalization of the pharmaceutical sector and the development of patent rights, such as this introduction of temporary protection, which may even have a negative effect on fashion industry. So it was a pleasure to talk to you, and I'm sure that your presentation will encourage us to learn more and more about Russian law. To keep in touch with us, you can follow us on Facebook, Twitter, and LinkedIn. You have links in chats, and please see our blog. We write more articles here. We'll be happy to receive your feedback and to see you on our next events too. So, спасибо большое за участие всем. Thank you for coming. Thank you for making the presentations.
Thank you very much to you, the students, the organizers, and Thierry Debled. Thank you for being with us. And well, sorry it was superficial, but we will. Well, I hope you got a general overview, and it's something that you will keep in mind after tonight's session. So thank you really for inviting us and for keeping up until now, although we know that the Prime Minister is now telling whether you will come back to classes or not. I don't know whether he already, well, he spoke an hour ago, so you'll maybe know whether you will go on holidays for Christmas. Actually, it's a more important question now. And yeah, good luck to everyone. Stay healthy, please. That's actually a good thing to do this year. And yeah, thank you, actually.
Thank you.
And on behalf of the CEIPI, once again, many thanks for this presentation. That was extremely interesting.
Thank you.
Thank you very much.
Have a good night. Bye-bye.
See you soon. Bye. See you next Thursday.